Hey, good morning. Welcome back to Do I Need a Lawyer? I'm your host, Gary Martin Hayes. Thank you for starting your day with us. And if you have a question that you'd like for me to answer, if you'd like to speak with me regarding a potential claim, just pick up the phone. Give us a call right now, 770-934-8000, or you can email me, gary@garymartinhayes.com. Now let's go to the question from one of our viewers. Hi, Gary. I have a question for you about my daughter's personal injury claim. She was in a wreck last year. The other driver turned left in front of her at a traffic light. My daughter was pretty banged up. Thankfully, nothing was broken, but the other driver is trying to put the blame on my daughter for causing the wreck, even though two other witnesses saw that man cause everything. Her attorney is telling her it will require her to file a lawsuit. What is involved with this process? And that comes to us from P. Monroe in Stone Mountain. Ms. Monroe, thank you for the question, and I'm very sorry to hear about your daughter's accident and her injuries. And these situations are very frustrating, especially when it's involving your daughter. As a parent, I know what you're going through. And you know your daughter didn't do anything wrong to cause the wreck. You have two independent witnesses that were identified at the scene of the wreck that told the police officer your daughter had the right-of-way and the defendant caused the wreck when he turned left in front of her. Yet now you have an insurance company not wanting to accept responsibility for the wreck and compensate your daughter for her medical bills, any lost wages, her injuries, or to even repair her vehicle. And this happens a lot, more often than people think. I wrote about this situation in the 2012 best-selling book, Protect and Defend. Insurance companies like to practice the 3 Ds when adjusting claims. They delay, they deny, and they defend. Delay? Well, when injured victims are bent over the financial barrel, the insurance company knows they can get most people to accept less money by delaying settling the claim. Well, deny. If you submit a claim that you were injured, the claims adjuster will attack your injuries in a variety of ways. They'll allege you're faking your injuries or you are exaggerating the severity of your injuries. And if you're really hurt, well, it was because you were injured before the wreck. Or if you were really hurt, you should have gone to a different doctor than the one you chose. Or defend. If you do not like what the insurance company is offering you, or if the insurance company denies your claim, you have 3 choices. Drop your claim, accept the lowball offer, or file a lawsuit. And then they will use the court system to delay the claim as your case falls in line behind every other civil claim, including business disputes, collection claims, divorce claims. Well, in your daughter's situation, it appears as though litigation may be her only alternative. And since she's currently represented by an attorney, I strongly encourage your daughter to schedule a time, get in, and meet with her lawyer to discuss her options. Well, let me talk about what happens when a case goes into litigation in Georgia for our viewers. The first thing you have to do, you have to file a complaint. A complaint is a personal injury lawsuit. It begins in Georgia with the filing of the complaint of the lawsuit by the person who is injured. They're called the plaintiff against the person who caused the wreck, and they're called the defendant. The complaint is essentially a written document that is filed with the court, and it has to set out the basic factual allegations against the defendant. The next thing is the summons. A sheriff's deputy or a marshal will then take a copy of the lawsuit and a summons to the defendant. They're served a copy of the lawsuit, and this puts them on notice of the lawsuit against them. And then they have to file an answer. After the complaint has been served, the defendant has 30 days in which to file an answer to the lawsuit. And the answer is essentially a legal document in which the defendant responds to all the allegations that the plaintiff has set forth in their complaint. And then discovery happens. Once the lawsuit is filed and the answer is filed, the discovery period begins. It's a 6-month period, and it essentially provides both sides a 6-month window to learn about or discover all facts about the case. They can take depositions of the parties, depositions of witnesses or treating physicians, and both parties can send written questions called interrogatories or request reduction of documents. This is a written subpoena essentially for documents and materials pertaining to the accident or the medical treatment or to any doctors, and a request to admit. These are a series of questions which the other party has to admit, deny, or tell the party that they can neither admit or deny because they don't know the answer to the question. And then trial happens. When that 6-month discovery period, when it ends, either party can ask the court to stipulate the case to the next available trial calendar. Some courts will automatically do this. Sometimes courts require the parties to stipulate the case. Now, as you can see, litigation is a very involved process. It takes a lot of time for the case to move through the system so it can be placed on a trial calendar. And litigation is not cheap. It can be very, very expensive because you have to factor in the cost of filing the lawsuit, hiring experts, taking depositions. It is not a cheap proposition, and insurance companies know this, and they certainly try to use this to their advantage. But don't let them wear you down. Please. Now, I know this is a lot of information. If you have questions about a personal injury case, the easiest thing that you can do is to pick up the phone and talk with a lawyer about your case. I'd be happy to talk to you about your claim. 770-934-8000, Gary Martin Hayes & Associates.